founder and director of the Cato Center for Constitutional Studies, which has become an important force in the national debate over constitutional interpretation and judicial philosophy. He is the publisher of the Cato Supreme Court Review and is an adjunct professor of government at Georgetown University. Prior to joining Cato, Mr. Pilon held 5 senior posts in the Reagan administration, including the State and Justice Department, and was a national fellow at Stanford's Hoover Institution. His writing has appeared in many publications such as the New York Times, Washington Post, and the Wall Street Journal. And he has appeared on many television programs, including ABC's Nightline, 60 Minutes, Fox News Channel, and CNN.
You're a Riley fan.
I'm a Handy.
What's that?
Handy Incomes?
No, I just go for the real stuff.
Yeah, he's a Rush Limbaugh copycat.
Oh, yeah. Oh! I'll tell him next time.
Mr. Pilon holds a BA from Columbia University, and MA and PhD from the University of Chicago, and a JD from George Washington University Law School. So without further ado, Mr. Roger Pilon.
Thank you very much, Ryan. It's good to be here. This is my, just telling some of the faculty, my 4th talk in 2 days at Alabama yesterday noon, and Ole Miss last night, LSU this afternoon. So I've been doing a lot of driving and a lot of speaking. Property rights. Are property rights opposed to environmental protection? That's, of all the subjects I gave Ryan, that's the one he picked, so I'll talk on that. The answers are no, not if you're talking about environmental protection strictly speaking, but if you're talking about environmental goods, yes, if unless you do it the right way, in which case they're not an impediment at all. All right, now let me make sense of those 2 seemingly contradictory answers to the question before us. And I'm going to do that, first of all, by noting that the issue of property rights is very much before the country now, has been for at least 2 years since the Kelo decision came down, New London v. Suzette Kelo v. New London, Connecticut, back 2 years ago. And the Supreme Court, in that decision, did little more than it had been doing for a number of years, but it awakened the country from its dogmatic slumbers, if I may put it that way, with respect to property rights. The O'Connor opinion was a ringing opinion that had words that electrified lots of people around the country, even though the opinion was based on one that she herself had written several years before. And owing to the good public relations work of the Institute for Justice, which had argued the case all the way to the Supreme Court, there has followed some 41 states who have that have instituted, either through legislation or through court decisions or through referenda, better protections for property owners against takings based upon the rationale of economic development. So what I want to do today is sort of capitalize on that movement by, first of all, suggesting that you will not get a clear picture of the issues that are before us with this question until you go back to the first principles of the matter. And that's what I'm going to do at the outset. And then I'm going to set forth 4 scenarios in which owners will come up against the government in various ways and show how they are or are not entitled to compensation under the takings clause as a result of those confrontations. And then I'm going to take the 4th of those and divide that into 4 scenarios. And after that, if I have time, I'll go through some of the cases to illustrate how it is that we got to where we are today. All right, when I say that I'm going to go back to the beginning, I mean by that not simply to the Constitution, but to the Declaration of Independence, because it's there that Jefferson and the other signers of the Declaration set forth their philosophy of government, and in doing so we're drawing upon a long history stretching back some 2,000 years to antiquity, indeed to, one could say, to Plato's Euthyphro, where Socrates asks Euthyphro, is piety pious because the gods love it, and the gods love it because it is pious? In other words, he was contrasting legal positivism on one hand and natural law theory on the other. The idea that piety is pious simply because the gods love it, legal positivism, a will theory of justification, or the idea that there are independent reasons why piety is pious and that's why the gods love it, the idea that justification is rooted in reason and this is universal to all mankind and this idea that there are certain principles of natural law, a higher law, right and wrong, from which to derive the positive law against which to criticize that law at any point in time, is a thesis that has been with us from antiquity onward. We see it developed somewhat in Plato, much more so in Aristotle, with the Stoics following the demise of the Greek city-states, the Middle Ages with Cicero and Seneca somewhat later, in the Middle Ages with the separation, or the battles between king and church, which led to inchoate notions of separation of powers. But it's especially in the English tradition where there were developed institutions to secure these principles that we see it really coming to the fore. Over the 500 years of the evolution of the common law, in which judges adjudicated cases or controversies that were brought before them between neighbors and then later between individuals and the king, you see the development of the theory of rights rooted in property that John Locke in 1690 would draw together when he sat down to draft the Second Treatise of Government to justify the Glorious Revolution of 1688. And what Locke did was draw upon principles of reason to set forth the theory of rights that Jefferson drew upon, to set forth the theory of property, and then the social contract theory. And we see this all very succinctly stated in the Declaration, beginning with that phrase, we hold these truths to be self-evident. Self-evident truths are truths that are rooted in reason. And you see what those truths are by noticing the first one is that all men are created equal, and then Jefferson defines that equality with reference to rights to life, liberty, and the pursuit of happiness, all of which rights are reducible to property, as Locke put it, lives, liberties, and estates, by which I mean property. And the importance of understanding the rooting of rights in property is that first you've got something to get hold of, and secondly, that will enable you to distinguish legitimate from illegitimate right claims. It's very easy to claim a right. It's quite another matter to make good on the claim. When it is that, when what you're claiming is something that is yours by right, something that is your property, something to which you are entitled, then what you want to know is whether you do indeed hold title to that thing free and clear. If you do, you hold it by right. Otherwise, it may be an interest, but not necessarily a right. And so that's the start of the theory of rights. It's not the epistemological foundations of it. That's the subject of another lecture. But at least it's the start of the casuistry with respect to reducing all rights to property. Now, of course, people don't live in splendid isolation on black acre or white acre. They come together in various ways, and there are two morally relevant ways, either by force or by promise or contract. When they commit torts or crimes, or when they enter into contracts, they change the world of rights and correlative obligations. They extinguish or alienate old rights and obligations and bring into being new rights and obligations, and thus the world of rights and obligations evolves over time with reference to these fundamental principles, starting with property and contract and showing how it is that that world of rights and obligations can change over time. Now, the one thing I want to focus on in the Declaration at the moment is this notion of a right to the pursuit of happiness, because with it you see an insight into the classical liberal mindset. What makes you happy is not necessarily what makes me happy. By implication, you've got a distinction between rights and values. The idea is that what makes you happy may be a subjective value of yours as opposed to the subjective value of mine. We therefore want to distinguish subjective values from objective rights. And by that, I mean to suggest that there is no epistemological foundation for the theory of value. We can reason about values, but as the economists are fond of reminding us, there's no accounting for taste. And so, what you have when you make this distinction is the idea that each of us has an objective right to pursue happiness by his subjective values, even though it may offend other people, provided he respects the objective rights of others to do the same. And what this enables you to do is thread your way between two alternatives that we inherited from antiquity, namely skepticism and dogmatism, neither of which is attractive. Skepticism holds that there are no moral truths, or if there are, we can't know them. Dogmatism holds that there are moral truths all over the place that are fit subjects for law, dealing with everything from the sexual practices that you're permitted to engage in, to the things that you're permitted to put into your body, and so on and so forth. Skepticism leaves you with no morality, nothing to get hold of. Dogmatism leaves you with no liberty. As I said, neither alternative is attractive. When you distinguish rights from values, as is implicit in this notion of a right to pursue happiness, then you are able to have morality that you can get hold of with reference to the theory of rights, but the liberty to pursue whatever values you want, provided you respect the equal rights of others to do the same. Now, with that outline of the theory of rights, Jefferson then turns in the second part of that famous paragraph to government. That to secure these rights, which rights? The ones I've just outlined. Governments are instituted among men, deriving their just powers from the consent of the governed. Thus, government is twice limited. It's limited first by its ends to secure our rights and by the means which must be consented to. The vision, therefore, is one of essentially libertarian live and let live, with government there to secure the rights we've got in that state of affairs and to do the few other things that we authorize government to do. And that's the same vision the founders took with them when they became framers some 11 years later to draft the Constitution. And we see that state of nature theory drawn from Locke, drawn from the Declaration, right in the preamble of the Constitution. We the people, for the purpose listed, do ordain and establish this Constitution. In other words, all power starts with the people. They create the government. They give the government whatever powers they give it. The government does not give the people their rights. I'm going into this early foundational stuff because it's important when we get to the issue of relating the police power with the eminent domain power to understand how it is that property rights come from this theory of natural law in the natural rights tradition. And so once you see that the preamble puts us in state of nature theory, and you see that the problem thereafter is, as Madison faced it, to create a government at once strong enough to do the few things that we wanted to do and to secure our rights, yet not so extensive and powerful as to violate rights in the process, you will then appreciate the checks and balances that follow. The separation of powers between the three branches of the government, each branch defined functionally, the division of power between the federal and state governments, with most power left with the states, the bicameral legislature, the unitary executive, the provision for independent judiciary with the power to oversee the political branches and later on the states, the provision for periodic elections to fill the offices set forth in the Constitution. But the main restraint on overweening government took the name of the doctrine of enumerated powers. And the idea can be stated no more simply than this. If you want to limit power, don't give it in the first place. We see that in the very first sentence of Article 1, all legislative power herein granted shall be vested in a Congress. By implication, not all power was herein granted. You look at Article 1, Section 8, and you see the main powers that were given to Congress. There were only 18 in number. Power to tax, power to borrow, power to regulate foreign and interstate commerce, and so forth. And then you look at the last documentary evidence of the founding period, the 10th Amendment, and you see the doctrine of enumerated powers spelled out explicitly. The powers not delegated to the United States, nor prohibited by it to the not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. In other words, the Constitution establishes a government with delegated, enumerated, and thus limited powers. And then you look at the 9th Amendment and you see the obverse of the 10th. The 10th speaks of powers, the 9th speaks of rights. And it's important to understand the history of the 9th Amendment because it gives you an insight about the idea of both enumerated and unenumerated rights. The 9th Amendment says the enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. There were objections to adding a Bill of Rights, even though it became clear during the ratification debate that a Bill of Rights would be necessary or the Constitution would not be ratified. The objections were twofold, namely, first, the Bill of Rights was unnecessary because, as Hamilton, Wilson, and others said, why declare that there's freedom of speech when no power is given with which to violate the freedom of speech? Moreover, they added a Bill of Rights would be dangerous. Why? Because you cannot enumerate all of our rights. There are in principle an infinite number of rights. But the failure to do so by ordinary principles of legal construction will be construed as meaning that those that are enumerated are to be protected as distinguished from those that are not. And so it was to address that problem that they wrote the 9th Amendment, which says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And so the picture that emerges from the Constitution is the same one that emerged from the Declaration, namely a world of libertarian, live and let live, each of us free to pursue happiness by his own values, provided he respects the rights of others, and government there to secure those rights and to do the few other things that we've authorized government to do. Now, where does property fit into this? It fits in as a background condition. You don't see an explicit list of rights that includes property to be protected. What you do find is that property is referred to in the Due Process Clause of the Fifth Amendment and in the Takings Clause. The Due Process Clause prohibits government from depriving people of life, liberty, or property without due process of law. The Takings Clause gives you two main restraints on the power of eminent domain, and in the course of doing so, makes it clear that there is a right to property by implication. Nor shall private property be taken for public use without just compensation. In other words, government can take property, provided it is for public use, and just compensation has been paid. Now, how do you correlate this protection, this oblique protection of property, with the main function of government to secure our rights? Well, it turns out that the main function of government to secure our rights belongs with the states, the general police power, not with the federal government. And the police power is what John Locke called in the second treatise the executive power that each of us enjoys in the state of nature, namely the power to secure our rights. And that's the power, the main power that we yield up to government in the original position when we create government. But notice that if it is the power to secure our rights, it's bounded by the rights that there are to be secured. And so what you have to do is get clear about what your rights are so you'll know the limits of the police power. Moreover, the implication is that if government is going to do something beyond securing our rights, it's got to do so through some other power. For example, if the government wants to build a post office, the framers didn't get it entirely right, if they want to build a post office, then they've got to find a power within the Constitution that authorizes the government to do that. And if it's necessary to acquire property to build that post office, they've got to do so through the exercise of the eminent domain power. And the eminent domain power must require that it's for public use and that just compensation is paid. And so the two powers are correlated as following. The police power is there to secure rights. If you want to do something other than that, you've got to use some other power, and in particular, if you want to seize property in the course of doing whatever other action you're going to pursue, it's got to be with respect to those two restraints, public use and just compensation. Now, let me go through 4 scenarios where owners will come up against the government. The first scenario is one in which an owner suffers a loss of value in his property because of something the government does. It may, for example, close a school in the neighborhood, or a military base in the community, or build a road a mile away from the original road where motels and restaurants and so forth are located. And the owners of those establishments and those properties suffer losses accordingly, and oftentimes think that the government owes them compensation for the losses that resulted from that government action. The answer is no, they are not entitled to compensation because the action of the government took nothing that belonged free and clear to the owners. They do not own the value in their property. The value is a function of what others are willing to offer, and it can be a function of many factors. So they took nothing that was owned free and clear by the owner. The second scenario involves a case in which the government condemns uses of a property owner that are injurious to his neighbor. Nuisances, creating vibrations, odors, particulate matter, noise, and so on and so forth, or prohibits the owner from using his property in ways that are excessively risky to the neighbor. And so here you've got something that will also result likely in a reduction in the value of the property. But once again, the owner is not entitled to compensation because this is an action that he had no right to engage in the first place. So what you've got here is a classic case of environmental protection. You can't use your property in such a way that it degrades your neighbor's property by spilling all kinds of nuisances or garbage or what have you, or despoiling the public domain such as air, water, and so forth with the use of your property. The government can prohibit you from those uses, and it doesn't have to compensate you at all for that. Thus, property rights are not only, it's not only the case that protection of property is not inconsistent with environmental protection. It is in the name of property rights, the property rights of the neighbor, that your uses are restricted so that he can enjoy free and clear of the uses that belong to his property. The third scenario is the regulatory takings one. And this is where so many problems come up today. This arises when the government condemns uses not to protect the neighbor's property, but to provide the public with various goods, lovely views, wildlife habitat, and the like. Here, what often happens is that the government condemns those uses, leaves the title with the owner, and pays him nothing for it, even though the value of his property may plummet markedly. I'll give you examples of that shortly. The fourth scenario is the full use of eminent domain. Not the condemnation of uses, but the condemnation of the whole property, including the title and the transfer of the title. And there are four variations of this. The first is where the title is transferred to the government, as, for example, when the government seizes the property in order to build a school or a fort or a road or something of the sort. Here there is no problem provided just compensation is paid. And just compensation entails leaving the owner indifferent as to whether he accepts the property or the compensation. Rarely, of course, is that the case today. Most often, just compensation is read as market value, which most often is well below what just compensation should be. In any event, the first scenario is not problematic. The second scenario is the one in which the government condemns the property, takes title, and then transfers it to another private party, but the other private party is a public utility of some sort, a railroad, a cable, a telephone company, telegraph line, and so on and so forth, that is available to all members of the public on a non-discriminatory basis, often with regulated rates of return. And here there is no problem either, because the public use restriction is satisfied, and indeed, if it were not the case that this is legitimate, then the public would not be able to take advantage of the relative efficiencies that flow from having these services performed in the private sector rather than in the public sector. The third and fourth scenarios are the difficult ones. This is the one where condemnation takes place for blight reduction, that's the third scenario, or for economic development, that's the fourth scenario. The two tend to blend into each other. The blight reduction case came, for example, from Berman v. Parker in 1954. It's the federal bulldozer that moves in, mows down whole neighborhoods in order to allow more upscale development to take place. Often the poorer people are the victims of this, and the upscale people are the beneficiaries of it. And as I said, closely related to blight reduction is economic development. That was the case in the Kelo case, whereby the government condemns property, transfers title to another owner, usually a developer well-connected, unlike the people whose property is condemned. Indeed, what you're dealing here oftentimes with is developers and other people who are well-connected with the government, as opposed to the less well-connected people. It's no accident that in the Kelo case, both the Cato Institute and the NAACP filed briefs on the side of Suzette Kelo, not on the side of the government. This is the case whereby the rationale is to increase the tax base, to bring in upscale industries and so forth. A classic case is the Pole Town one from Detroit in 1981, decided by the Supreme Court of Michigan, in which the city of Detroit condemned some 38 homes and small businesses in order to make way for a Cadillac plant on the ground that it would ensure jobs and a better tax base and so forth. Promises that are rarely, if ever, met by the people, the politicians who make them, who are usually long gone by the time the project is completed. And so this is again an abuse of the power of eminent domain, because what happens in these cases, as happened in the Kelo case, is that the term public use is read as public benefit. And therein lies the problem, because public use is meant to restrain government. Public benefit facilitates government, because there is no project that cannot at some level be said to benefit the public, and so it's essentially an open sesame for government condemnations, as the case may be. All right, I am going to go back now to the third and fourth scenarios of the first four that I said, and give you a little more detail on those. In particular, I'm going to focus on, I'll start on the fourth and just wrap that up. That's the full use of eminent domain. Here, what you've got, as I said, is something like the the Kelo case, the Poletown case, which, by the way, was reversed by the Michigan Supreme Court in a unanimous decision in 2004, the Pavcock case, and then the Ohio Supreme Court in a decision just in 2006 did the same thing as the Michigan Supreme Court did. And so we have that local part of 41 states that have markedly improved the situation with respect to economic development condemnations. I'm going to focus right now on the regulatory takings issue because this is where so much of the mischief takes place. This, one could say, in the modern era began with a case called Block v. Hirsch, a pair of rent control cases out of the District of Columbia and Washington and New York during World War I. And the cases were decided by the sainted Justice Oliver Wendell Holmes, a paradigmatic progressive who never saw a scheme for planning that he didn't like. And so what you've got here is a situation where the parties have divided, have sorted out their relationships by contract, and yet the taking of the property of the landlord was upheld for reasons of exigent circumstances. Well, a year later, Holmes was faced with another case, the Pennsylvania Coal v. Mahon, and this is often thought to be the granddaddy of the regulatory takings cases. Here, too, the parties had sorted out the relationships between themselves. The coal companies wanted to mine the coal in Pennsylvania, and there were well-known risks in doing so, namely the risk of cave-in. And so they divided the estates into three. There was the surface estate, the mineral estate, and between the two, the support estate. And the idea was that during the time that they're mining, the surface estate could continue to be farmed, or whatever else the people did on the surface. But the question arose at contract, who's going to bear the risk of subsidence? And it was decided between the parties that the surface owners would do so, and they were paid handsomely for that by contract. Well, as the mining commenced and the coal companies eventually turned to mining the support estates, you started getting cave-ins. And what do you suppose the good burghers of Pennsylvania did? They ran to the legislature to seek relief from the losses that they saw themselves suffering, even though they had been paid to bear the risk of those losses. And by the time it got to the Supreme Court and the court sought to decide it, we see Holmes wrestling mightily with this issue and coming up with the grand conclusion that if a regulation goes too far, then it constitutes a taking. Well, with that bright line, too far, we have had what Justice Antonin Scalia called 70-odd years of ad hoc regulatory takings jurisprudence when he decided the case of David Lucas in 1992, even as Scalia was adding another year to the string. The Lucas case I'm going to go to because it is so emblematic of what's wrong with regulatory takings. In 1986, David Lucas bought 2 parcels of land on the Outer Banks of South Carolina near Charleston with the idea of building a home for himself on one and a home to sell on the other. He paid nearly $1 million for those 2 parcels. Nothing extraordinary in this. There were homes on either side of his lots and between his lots. Between the time he bought the parcels and he commenced building, the state of South Carolina passed the Beachfront Management Act in order to promote tourism, to preserve certain flora and fauna, and the like. The effect of this statute was to render his lots useless. He could pitch a tent, he could have a picnic on them, but it was pretty expensive tenting property, $1 million. And so he did what every red-blooded American would do, he sued. And he won at trial, but at the Supreme Court level of South Carolina, he lost 3-2. And he filed a cert petition with the Supreme Court and was fortunate that the court granted cert. And the court reversed 5-4 the South Carolina Supreme Court. But it did so on a theory from Scalia that this was a complete wipeout. And since it was a wipeout, he was entitled to compensation. The problem with that thesis, however, is that most regulatory takings don't amount to wipeouts. They reduce the value of your property maybe 50% or 75%, and you get nothing in those kinds of cases. Indeed, Justice Stevens in dissent said, well, what about the guy who suffers 95% loss? To which Scalia said, well, takings law is full of these all-or-nothing situations. Well, thank you very much, Nino, for that counsel of despair. But in any event, This is one branch of the regulatory takings area. There are other branches. If there is a physical invasion, then you get compensation. If, for example, the government floods your property, or if they're shooting over your property, or if there are low flights over your property, or if there's a cable box attached to your apartment building in the Loyola decision of 1981, then you're going to get compensation. If there is no nexus between the regulation and the purpose of the regulation, you're entitled to compensation. The Nolan decision of 1987, the Dolan decision of 1992, both of which involved efforts by the owners to get a permit to build, and the government said, well, you can get your permit only if you give us an easement over your property. And so what you've got here is the government putting the owners to a choice between two of their entitlements. Their right to get the permit, other things being equal, and their right not to give up an easement free and clear. As Scalia put it in the Nolan case, this is nothing but an out-and-out plan of extortion. He was absolutely right on that. So in these kinds of nexus cases, you will get it sometimes in temporary takings. But largely, regulatory takings are decided under the so-called Penn Central case, which is a three-pronged test which, if you know the meaning of it, you're doing far better than the Supreme Court is. It is absolute hocus pocus. The only thing you really need to know is if you're up against the Penn Central test, you will lose. And so we have had lots of cases of this kind over the years, and the court has made an absolute hash of it because, of course, it has no theory of the matter. Going back to the Block v. Hirsch, the rent control case, and the Pennsylvania coal, the mining case, both of those should have been easily decided because the parties had sorted out the relationships between them. The problem is that when you get a case that requires repair to natural rights theory, as happened in the City of Euclid case 4 years later after Mahon in the 1926, you then have to go to natural rights principles because the parties hadn't sorted them out. That was a challenge to a zoning restriction in the City of Euclid, Ohio, that reduced the value of the property of the plaintiff by 75%. He lost, the zoning ordinance was upheld, he was out 75% of the value of his property. And this kind of thing is going on all over the country. I have not gotten into the draconian procedural problems that you're up against, the Williamson County test, the full faith and credit restrictions, the kinds of things that came up in the San Remo case that the court handed down in 2005, a year in which it decided 3 property rights cases in which the owner was had a very credible case in each one, and yet in all 3 cases the owner lost. What we've got here is a loss of understanding of the fundamental principles. In the 17th and 18th centuries, the power of eminent domain was understood as the despotic power. Why? It's because none of us in a state of nature would have the power to condemn his neighbor's property, even if we did have a very worthy cause, and even if we did pay the owner just compensation. Why? Because it's a forced association. So how can you justify eminent domain if none of us had this power, and therefore in the original position, none of us could have given it up to the government? Well, there are 2 rationales which give you a second best justification for it. The first is that in the original position, we all gave the government this power unanimously, at least so the story goes about the original position. Of course, none of us was in the original position, but at least that's the rationale from consent theory. The second is one that's drawn from economics, which Walter will understand. It is said that eminent domain is Pareto superior. That is to say, at least one person is made better off and no one is made worse off. The person who's made better off is the public, by evidence, as is evidenced by its willingness to pay. The person who's not made worse off is the owner, provided he received just compensation. That is to say that he reaches that point on the indifference curve as to where he is indifferent as to whether he gets the property or the compensation. And again, that is rarely the case. Once you understand the nature of the eminent domain power and see it as the despotic power, then you will have a grasp of why it is that you want to have a heavy burden of proof on government before it exercises this power, whether in its complete form or in its regulatory takings form. The problem today, however, is that after the Progressive era, which Holmes was an exemplar, indeed one of the leading figures in which we fundamentally changed the climate of ideas in this country with respect to the relationship between the individual and government, in which we abandoned the insight of the framers that government is a necessary evil, and started seeing government as an engine of good, an instrument through which to solve all manner of social and economic problems. The era in which we switched from natural rights theory to utilitarianism, from principle to policy, the era in which we unleashed the social planner of whatever stripe, that is the era that we are in today. And whereas it used to be the case at common law that people could use their property freely, and the burden was upon those who objected to show why it is that rights of theirs were being violated by the use of this property, today you cannot use your property unless you've got a permit in most jurisdictions, and that means federal, state, regional, and local, and these people can tie you up until you die. Indeed, in the Lake Tahoe case, some 700 plaintiffs initiated these suits way back in the 80s. By the time the Supreme Court decided it years and years later, a third of them were dead. And so this is what you're up against as a property owner today. It is not a pretty picture, but fortunately, after the Kelo case, people got good and mad. And in the last election, there were 9 property rights issues on the ballot. Nixon 12, 9 of them won. Even in California, the worst state in the country, the property initiative, Prop 90, lost by only 52 to 47. So the time may be coming when people are going to be more respectful of property than they have been since the era of the progressives. And with that, I will conclude and invite some comment. Thank you. Good enough to work with, I guess.
Oh, we use.
No, I mean in my way of commentary.
Oh, sure.
Yeah.
We use.
I've given you enough red meat.
Yeah, the pizza. I had to take notes. No, I'm just going to say a couple of things, probably for 5 minutes or so. One is thanks very much for coming. It's what you don't know this, but we've got conservatives, liberals, and everything in between.
I rather thought so.
And some of them are getting.
Yeah, they weren't wearing labels, but I could see.
Yeah. And some of them are getting extra credit for this. So,
well,
so that's good, right?
Just the liberals.
I just wanted to respond to a couple of things. My reaction both to the idea of principles, first principles in property, and then talk just a little bit about Lucas and a little bit about Kelo. I happened to have written an amicus brief in the Kelo case, and defended regularly against conservatives, liberals, and all of my students who think I took the wrong position. One point, as someone who teaches property and writes about it and thinks about it a lot, I think that it's worth knowing that there's more than one way to understand property that has a historical basis. From the very beginning of Western law, property was a coin that had 2 sides. It had one side that was involved in private property interests and another side that was involved with public property interests. And what I mean by private is what the owner could do with his or her land. And what I mean by public is expectations and benefits that the public had the right to expect from landowners. This goes all the way back to Roman law. You can find in Roman law zoning codes. You can find laws that say brick kilns go here because they pollute. Butchers, these other sorts of things go in other areas. And so there's a very long tradition of government telling owners what they may and may not do on their land in some situations. You can go way back before John Locke, and I love this example, recorded in the Leet Rolls of Norwich in 1289, when William Skinner was held liable for having thrown the dead bodies of cats into a pit whereby the air is poisoned. And what's important to see about this is this gentleman was held liable not because he was damaging somebody else's property rights. He was damaging the public, people who were walking by, who might not have owned property, all right, who might not have even been free in ways that we would understand today. So we see this today. I mean, when we have laws that restrict sulfur coming out of smokestacks, that's a way of protecting the public interest, whether or not you happen to own property near a smokestack. Well, we have laws that discriminate or that prohibit racial discrimination. In the South, there were actually cases in which owners of restaurants who had to now admit blacks said that their property had been devalued because they couldn't maintain it all white. But never once did we consider giving them compensation because they lost the power to do something on their property. Because there was a public interest that they owed. You could look back in colonial times in the United States, and it's amazing how many cases you find in exactly this way. You can find cases in colonial times in the United States where laws were passed to require private property owners to plant trees to provide shade for people to walk along sidewalks. You can find cases where people are required to let roaming sheep graze on their fields, even though the sheep aren't theirs, and even though the sheep don't belong to property owners neighboring by. A few of these cases, Barrett v. New York, 1917, upholds the New York law that prohibits killing beavers on private land, even if the beavers are chewing all your trees up. And the court finds, it says the public right to protect wildlife goes back to colonial times in the 1700s. Okay? The wildlife was a public benefit. It wasn't anybody's own pets or these sorts of things. Lawton v. Steele, an 1894 case, the U.S. Supreme Court allows the state to destroy private fishing nets to protect public fish, saying again that it's part of that tradition. Now, my point is not to convince you whether these cases are right or wrong. My point is to convince you that from the very beginning of Anglo-American law, there were two sides to property. Now, I can't argue, or I can't I won't release today, make the case that that's normatively correct, although I think it is. But what I can make the case for is that we've always seen it that way. It has never, in the history of this country, been the tradition that we compensate landowners for taking away or for restricting uses on their property. A guy named Joe Sachs studied this. He's at UC Berkeley. He studied this for many, many years. Studied the history of the national parks and so on. Has a very interesting quote. He says, the idea that owners should be compensated for restrictions that have any economic impact, whatever, represents, these are his words, a radical departure from existing law and precedent, not only in this country, but everywhere in the world. And it would enact a view that has been repeatedly and explicitly rejected by the Supreme Court of the United States over its entire history. It has never been a law that a property owner has a right to exact every possible economic benefit permitted by virtually every unbridled use and development, whether the subject is regulation of land or drugs, airplane safety or banks, mine safety or setbacks and height limits. Now, whether you agree with whether that's appropriate or not, it's just important to realize that there's always been another fundamental point that's even more fundamental than John Locke. All right, and Locke would have understood. He was an empiricist. He based his ideas on reason, but also on observation and experience. And when observation and experience changes, the Supreme Court has changed too. We used to own property all the way to the very heavens. We don't anymore, so that airplanes can fly by. You might argue that was the country's greatest uncompensated taking when that happened, and there were early lawsuits about that. But again, sort of practicality intervenes, and that fundamental principle that goes even beyond John Locke is physics. You know, you can have all the natural law you want, and if you've got endangered species that are becoming extinct at 1,000 times the background level, or if you've got 40,000 people a year dying from air pollution, which they are in this country, or if you've got a football field's worth of protective wetlands vanishing every half an hour in Louisiana, your idea of what's natural in terms of law has to change. And at least that's my own view, and that's the view that the Supreme Court has had from the very beginning. I find it interesting. I'm one who doesn't mind the living Constitution and judicial activism, and the idea of regulatory takings is exactly the product of activism. The founders never in a million years would have thought that regulation itself would amount to a taking. It didn't happen until Oliver Wendell Holmes invented the concept. And in fact, there's a history, as I've already explained, of regulations on land. Now, we have more regulations today, and that's certainly different. But the idea that a regulation could amount to a taking was an invention of the 20th century. I think it's a good invention. I think we need it. But it's nothing that John Locke thought of. It's nothing that is hardwired into the Constitution. It's something that has been found, like a lot of other things. The only thing, I guess, I'm not sure that we got to the point of whether property rights are opposed to environmental protection. I guess I would just simply say I think it unlikely, because if I understand it, just having property rights doesn't protect the environment if you think of the environment as also including public interest. I'll give you just one example, the Louisiana wetlands. We lose 25 square miles of wetlands a year. Half of that is because of the way that owners, that is owners of property interests in the wetlands, are allowed to treat their property by digging canals through it, slicing and dicing it up in a million other ways. If you think that use by the oil and gas industry and the transportation industry, if you think that use has been in our self-interest in terms of protecting us from hurricanes, then you would subscribe to the idea that when private landowners have their land, they protect it in a way that benefits the environment. But it doesn't. I mean, it may protect themselves, it may protect their own interests, it may protect us as consumers, but it doesn't protect our environmental interests. And that's why we turn to regulation. That's why we have regulation. If you look at these major environmental statutes we have in the legislative history, there's almost always a reference that says private nuisance law could not help this problem, or the pre-existing state law did not help this problem. That's why we have to do it. Now, whether or not you want environmental protection is another thing, but to think that property rights in the aggregate would somehow get us there, I think is wrong. I'll just say a couple things about Lucas and about Pilon. Lucas is a really interesting case that has fabulous facts, which is why it got to the U.S. Supreme Court. It was designed from the very beginning to go to the Supreme Court, just like the Brown v. Board cases were. Lucas, from the very beginning in that regulation, had the opportunity to apply for a waiver, which he probably would have gotten. He was encouraged not to tee the case up for the U.S. Supreme Court. That's exactly what happened. And so Lucas, from the very beginning, had a way out and didn't use it. The restriction there had a lot more to do with just protecting flora and fauna. It had to do with protecting coastal land against erosion so that it wouldn't hurt the other houses that already existed around there. And it was pretty clear, if you read Kennedy's comments in that case, who came from California and understood coasts, if you read that, I mean, he buys that. He says, you know what, building more houses on this soil is dangerous and can contribute to erosion that will hurt other people's property. But the other members of the court didn't believe that, and that in part explains that case. At any rate, the hurricanes whip around that area and destroyed houses since. And so it's a question whether anyone should be able to build there at all. As far as the Kelo case, I'll just give you my 2-second blurb on Kelo, and that is that it's always been very hard to decide what a public use is. And I don't buy the distinction that private railroads are public uses, but that a private shopping mall and office building and parking lot isn't a public use. It just seems too fake to me. I've had Bush supporters try to explain to me that when George Bush bought the Rangers and then got the city of Arlington, I think it was, to condemn private property so that they could have a stadium that would be run essentially privately. I've had people try to explain to me that that was really a public use because the stadium was open to anybody who could afford the ticket. If that's public use, then so is this shopping mall. And so is this office building. If you don't want public use like that, and if you want to insist that the government own anything, then I think it's pretty unworkable unless you want a system where the government owns all the railroads, and the government owns all the shopping malls, and the government owns all the stadiums, which is not a libertarian position, I wouldn't suppose. So it's just a hard nut to crack, but for what it's worth, that doctrine goes all the way back to the turn of the 20th century. I mean, it wasn't just Berman in the 1950s that created that doctrine. It went way before that. And so this idea that suddenly there's something new that happened, I just don't agree with. The way I justify Kelo is this, is to me constitutional rights are there to protect people who don't have their own power to protect themselves in the legislature, which is why I think we have strict scrutiny or stronger laws to protect religious minorities, racial minorities, these sorts of things. To my mind, we don't need extra strong protections for people with lots of property. And I like the Kelo example because it proves the point. We have 40 some odd states now in which citizens are using their power to preserve rights they think are important in the legislature. You would never have seen 40 states lobbying their legislatures to desegregate schools in the 1950s, right? And the difference is that there was a group in the 1950s that didn't have a political base in which they could have protected themselves, whereas property owners often fall into that category. So it's not that property is less important than civil rights. It's that people who need their civil rights have less of an opportunity to claim them through a democratic process. So that's a little bit about my thinking. I see property as more broad than private property. I see it as expanding into public interest as well.
Professor.
I'd like to roll with Bill or I'll give you the last word.
Yeah.
Professor Verchick is, my aim was to try and sharpen things up. Professor Verchick is trying to muddy them up. And you saw that in various places, they start with private and public and so forth. If we can't draw sharp lines, we end up with no law at all. And that's part of the problem here. The economic impact, he said, Joe Sachs has said economic impact does not require compensation. I never said that economic impact required. In fact, that's one of the first points that I made, is that economic impact is not per se the issue that you looked for. Otherwise, every time you change the road and there's economic impact, you've got to get compensation for it. Locke was an empiricist in his epistemology, in his ethics. He was a rationalist. With respect to the air rights, again, this is you start with something like Lord Cook's ad coelum rule. You own from the nadir, the center of the earth, to the zenith. That's where you start. That doesn't mean you can't have overflights at 35,000 feet, but it does mean that you can't have overflights at 100 feet. And somewhere between the two, you've got to draw a public line, and that's exactly what is a proper place for statutory law. With respect to the regulatory, we never imagined that regulations amounted to taking, and that's a very new idea. Well, of course, the problem is, and this you did say to some extent, regulation is a relatively new, it's a 200 years ago, we didn't have the modern regulatory state. To say that Suzette Kelo was able to protect herself in the legislature, by definition, she was unable to protect herself in the legislature. Yes, after this draconian decision came down, people went to the legislature to try to protect themselves. But this idea that, the whole idea of the taking clause is to allow individuals not to be used. And that is the main objection I have to what Professor Verchick said. Namely that, take Lucas, and Lucas was not, he did not go to the state Supreme legislature and say, pass this law so I can tee this case up for a Supreme Court appointment. He may have at one time refused, and I talked with him, and he did refuse to take the offer that they put to him because it was a compromise. He wanted to stand on the principle of the matter. And so, when you got this idea that this was passed to protect coastal land from erosion, maybe that is so. But don't put all the burden on David Lucas. He's asked to contribute $1 million to protect the land that his neighbors are on. That's not the way we do it in this country. We treat individuals as individuals. If the public wants to protect flora, fauna, and so forth, it can do so. But it's got to pay for it. After all, if an individual, in order to prevent you from using your property in a way that takes from him a benefit he enjoys because of your failure to use it that way, can do it only by getting an injunction from you, why is the government in any better position than the neighbor? If the neighbor, in order to, say, enjoy the view that runs over your property, has to either has to go to you and buy an injunction running with the property, the government should be in no better position. They can't just simply write a regulation and say, now you can't build that second story in your house because it blocks your neighbor's view. The neighbor doesn't own that view. He enjoys that view, but it runs over your property, and you've got a right to use your property exactly as he does his. And so what I'm trying to do is sharpen these issues up to give us some lines that the court can work with. Unfortunately, we've got, as I said, something like the Penn Central decision. And if you really want to see how bad it is, go read that decision, and your head will spin when you're through. Okay, let's have some questions.
Yeah, we got a class coming.
We got a class coming in? I thought it was 6 o'clock.
Yeah, I thought we had a little longer, but.
Oh, really? Oh, I'm going to be outside if you want to ask me some questions.
All right, thank you for everybody coming.
Nice to see you.